got a quarter.
Due to the graphic nature of the following program, viewer discretion is advised.
Mr. Heller, did you have an opportunity to review the report?
I did, Your Honor.
All right. Ms. Jackson, is there anything the city wants to place in the record relative to the sentencing of this matter?
No, Your Honor.
Thank you. Mr. Heller, go ahead whenever you're ready.
Thank you, Your Honor. I did have an opportunity to read the pre-sentence investigation report. I do believe it to be complete and accurate as far as my knowledge goes. We are here for sentencing on a second and 10 DUI. OVI. Ms. Williams is respectfully requesting the opportunity to be placed on a community control sanction along with the conditions recommended in the PSI. We would ask the court to please consider allowing her to serve 5 days beginning today with the 18 days of home electronic monitoring subsequent to that.
Is she in a position to pay for the electronic monitoring?
She is not, Your Honor. She's a single mother of 2 children, Your Honor. She has minor children. She has 1 adult child. She does work 2 jobs, both part-time in a local nursing home and a daycare. She has no criminal record other than traffic offenses in these 2 OVIs. So she's certainly not violent, no criminal history. This was a situation she did drive. She had just found out her sister had passed away, jumped in the car to go to her mother's house, and she was stopped very close to her own home. She was polite and cooperative, did submit to the field sobriety. It is marked as refusal, however, it was clear that she attempted to use the intoxilizer machine, but she could not obtain a valid sample or provide a valid sample by blowing. She's very apologetic. The 5 days is going to be a stress on her. She had to make child arrangements. She knows it's her fault, and she wants to begin getting it over with today. Other than that, we would ask for a minimum fine and cost to be imposed.
Thank you. So the first one was in 2016, is that?
Yes, Your Honor.
Okay, just check it, okay. Has the vehicle been immobilized at all during the course of these proceedings?
Where's the vehicle
Parked
now? In your driveway?
at my mother's house.
It's parked at her mother's house. It has not been immobilized, right?
Vehicle's registered to you, ma'am?
Is the vehicle registered to you?
I got driving papers.
Yes.
She gave me driving papers.
Okay. Was there insurance, Mr. Heller?
Not shown at the time. Do you have insurance? See it. It's
I
on your
don't
phone.
have it on me. I had to go and tell her. I thought she already said
If you
that.
had insurance at the time of the stop, you can show it to the BMV, ma'am, but...
Yes, Your Honor.
Okay.
Your Honor?
Yes.
Would the court consider imposing and terminating the immobilization since she has been granted privileges for some time?
Was she not under an ALS suspension?
I don't have a...
No, it's a mandatory term of sentencing. I mean, I understand when people don't want to do immobilization prior to conviction. I get that. But it's a mandatory term of sentencing, just like all the rest of it. Right.
Talking about something else.
All right, I'm imposing the minimum mandatory fine of $525. Costs are waived. Three years active probation to include substance abuse assessment, follow any recommendations of the substance abuse assessment, also substance abuse testing, 4 MAD meetings. The vehicle is to be immobilized for 90 days. Interlock with restricted license and plates if occupational privileges are granted. And scram device for 90 days. I am going to allow 5 days jail with the minimum 18 days home electronic monitoring. The defendant will have a scram device applied prior to departure from jail. She'll wear the scram device for 90 days. The scram device, ma'am, will indicate to the court whether or not there's any alcohol use. So it's my expectation that the probation department will have you get an assessment as soon as possible. If treatment's indicated, you can go to treatment. And people have been shown to have success in treatment where there's a scram device in place. So hopefully that will be help. Thank you.
That's different.
All right. So, all right. What was the vehicle in the impound lot for any days? Because I can credit those
They
days.
tow it? They let you were so close to home, you didn't drive
No,
to
they
it?
let it stay there.
No impound days.
Okay. All right.
But then they want me to pay.
All right. I'm going to need the,
I
well,
lost my job.
yes, I have.
But I had no way there.
We're going to need the make, model, VIN number, which we probably have, license plate number, and the address where the vehicle is and where it's going to remain. That. I think so.
Just put it in before.
We're missing a lot of stuff.
Well, no, she's going to be remanded 5 days. Is there anything further? That's it? Okay, thank you.
Did the court announce a license suspension?
Oh, 3 years, from 9/22/18 till 9/21/21. If the defendant's successful in treatment and maintains sustained sobriety, I'll certainly consider reducing the period of active probation as well as the suspension.
Yes, Your Honor.
Thank you. Mr. Brown, are you represented today?
No, I choose to represent myself. If it's possible, try to
You
do it.
can. You have the right to an attorney if you want to have a...
No. Well, good day.
Well, let me just make a record here first. The reason we're here is that on December 18th, you tested positive for marijuana, and that you have been, there have been attempts to refer you to substance abuse counseling. However, you were discharged from Orca House due to behavioral issues. Then you were discharged from task for the failure to engage in treatment. According to probation, you indicated you were attempting to get services at more counseling, but could not provide documentation. And so the issue is you've been ordered to go to treatment, so what's going on?
That's just, I've been, I've attempted to go to treatment. The thing is, I have the paperwork and documents here that I never got discharged from Orca House. Orca House basically has covered up a lot of stuff that happened there. I filed for a grievance from a staff member that was being very mistreating me along with other clients that were there and stuff like that. He wound up getting fired after I filed for a grievance.
I'm not, okay. Let's just, do you want a full evidentiary hearing on this probation violation? There is a positive marijuana test.
I mean, full
Marijuana is still illegal in the state of Ohio.
Right. And I have my explanatory for that too. While I was seeking treatment and stuff like that, I have fibromyalgia, mind you. I'm not using it as no excuse or anything, because I don't. My use of that is not for recreation use. It comes down to.
So my question is, let me pose this again.
You mean to hear it? I'm gonna shut up.
Do you want a full evidentiary hearing on this alleged probation violation?
Yes.
So I would expect that you consult with an attorney to represent you. If you represent yourself at a full hearing, I'm going to have you sign a waiver.
Okay.
Because you have the right to an attorney. It's a fundamental right we all have. Because you could go to jail. Okay, you understand?
Right.
So let's schedule it, please. Did they give you a clean date in probation?
A clean
At
date?
December 18th, did they say test again in 45 days and be clean or not?
I'm not for sure.
Well, you would know if they told you that.
No, I ain't hear that. I ain't hear anything like that.
I'm going to give you a clean date.
Okay.
February 12th.
All right, so I don't know if you can stay clean. I mean, the problem is you've been ordered to do something and you're not doing it. Okay, so your position is you've made efforts to do it. You know, I'm going to indicate the probation officer needs to be present. And, you know, you need to bring any evidence. Talk to your attorney. You have the right to an attorney.
All right.
Okay, we'll see you on February 12th.
Yep. See?
Mr. Williams, what are we doing here?
Just missed the date.
You missed a date. You failed to
Yeah.
report. That's what it says.
Yeah, I called him, but I had the dates mixed up, and then when I went in, he told me that I had to come to court because and he got the wrong phone number for me. He said he tried to call me, but he called on the old number, and I gave him
All right, so you did treat. You went to treatment.
Yeah, I did everything but pay the $96, and I'm gonna pay
Okay.
that Friday.
Okay, so you missed on December 6th and December 20th. That's what they're saying.
Yeah, I missed
And you
December.
met on January 3rd. He accepted full responsibility. Okay, well,
I
I
never
don't know
knew
why
about
they
it.
even sent this up here. Okay, you failed to report. I'm going to just continue probation. You certainly have the right if you want to go and get a lawyer and have a whole hearing about this, but it sounds like you admit that you missed your appointments.
But, Judge, I was wondering if I pay the fine, it's the only thing that I haven't done. He was saying if I pay the fine Friday, maybe I could ask for inactive. I've been on over a year.
Yeah,
So pay the
that
fine.
that
and-
would be a possibility, yes. And so all your probation officer has to do is send an email to me once that's completed.
Yes, ma'am.
Okay, if all the other terms are done, which it looks like they are. So let me just see. 11/28/20. Okay, so you're back on track. Thank you.
All right, thank you, Judge.
At this time, City is going to amend to Ohio Revised Code 2903.14, negligent assault, a misdemeanor of the third degree. City's understand defendant will plead guilty to that amended charge.
This is your understanding, Mr. Haller?
It is, Your Honor.
Okay. I'm sorry, I just don't want. All right, Mr. McIntyre, count one is amended to revise code 2903.14, negligent assault. This is a misdemeanor of the third degree. Maximum fine is $500. It carries up to 60 jail days. These are the maximum possible penalties. Do you understand?
Yes.
You understand you have the right to a trial by jury or a trial to the court on the original charge of domestic violence. You're giving up that right today by entering a guilty plea to a reduced charge of negligent assault, a misdemeanor of the third degree. Do you understand?
Yes.
Are you waiving reading of the facts?
We are, Your Honor.
Facts are waived. if you wish to enter a guilty plea to count 1 as amended to negligent assault, please state guilty.
Guilty.
I accept the guilty plea. I do make a finding of guilt. Excuse me. And I guess it would be appropriate to have a pre-sentence report. So let's go with February 5th at 10:30. 2/5. 10:30 for a PSI. So you'll go down to probation today, sir.
Okay.
They'll talk to you, and they'll have a report ready for me on February 5th. And then, Ms. Powell, did you?
May we approach briefly?
Yes.
Thank you.
All right, well, it's been brought to the court's attention that there is a no contact order in this case. It was ordered on the 3rd floor back on November 13th of 2018. This case began. It's my understanding that the prosecutor was speaking with her complaining witness this morning and later had a conversation with Mr. McIntyre, which indicated that you had come in together this morning. And in addition to that, that you had discussion about going to get hot dogs after the hearing was over.
Yeah.
Well, you know, when the court makes a no contact order and the order is violated, Mr. McIntyre, that is punishable by a contempt of court citation, which means I could send you to jail for 30 days for violating my order. There's a reason why the court orders no contact. Clearly, the parties have just ignored it. So, for everyone's life to be made more simple today, I'm going to lift the no contact order so that we don't have to worry about who's coming to court together and going for lunch afterwards. I will tell you, though, Mr. McIntyre, you're the defendant in this case. If something bad happens between today and your sentencing date, you have been fully informed. You know, the best thing you can do right now is stay away from this lady for your own benefit and for hers. Stay away. But I am going to lift the no contact order. And you're going to be sentenced on February 5th. So make sure nothing bad happens.
Okay, Your Honor. Can I say one thing?
No, don't say it. I think you and your attorney can, if you want to,
Okay. Thank
go
you.
get your hot dogs.
Okay.
Ms. McEwen, you're charged with driving under suspension. This is a final, looks like a final pretrial today. My records indicate you have limited privileges. Is that correct information?
Yes.
Let's see. This is an M1. You understand you have the right to an attorney. I did inform you of that back on November 28th.
Yes.
So did you want to resolve this matter today
Yes,
with the
please.
city? And
Yes.
you're comfortable not being represented by an attorney?
Yes.
All right, well, you can go ahead and talk to her and see.
Your Honor, I believe we have an understanding.
Okay?
It's my understanding the defendant intends to plead guilty to the A charge. With that guilty plea forthcoming, the city moves to knowledge the B, C, and D charges. Valid insurance was not shown.
Okay, thank you. All right, so this was driving under an OVI suspension? It was not charged as such.
Right? She got off.
You dodged a bullet there. Driving under an OVI suspension, if it's charged that way, carries a mandatory 3-day jail sentence. So, as it's charged, it's just a garden variety driving under suspension. Maximum fine $1,000, up to 180 jail days, 2 points on your driver's license. You understand that, ma'am?
Yes, ma'am.
You have the right to a trial or a trial by jury on all charges pending against you. You're giving up that right today by entering a guilty plea to just driving under suspension. Do you understand that?
Yes, ma'am.
Do you wish to enter a guilty plea to driving under suspension, a misdemeanor of the first degree?
Yes.
I accept the guilty plea. I do make a finding of guilt. Defendant waived right to counsel. Nolly the balance. $300, I'll waive the costs. It's driving under an OVI suspension. Your license is suspended until August of this year on that. Don't drive outside of your limited privileges, because if you get a driving under an OVI suspension, you're going to go to jail. Okay? Yeah. Okay. If you need time to pay or community work service in lieu of fine, please speak to the clerk of courts. They'll go over everything with you. If at a later time you are completely unable to meet your obligation, I will have an ability to pay hearing, at which time you have the right to an attorney, and I will take evidence about your ability or inability to meet your obligation. Thank you. Have a seat outside. Good morning, sir.
How you doing? Yeah.
Now I'm hungry. You've been talking about hot dogs in here. Now I'm hungry. Okay. Just for the record, Ms. Jackson, Mr. Oh, Lord. Well, we have a case from 2011. That's over our age guidelines. So I'm dismissing that, and I'm dismissing the two from 2013. Those are also more than over age. They're aged out. So that leaves the 2014 cases. Two driving under suspensions. Do you have a valid license, Mr. Smith?
No, I don't, Your Honor. I've been working on it.
Do you want to see an attorney and just take care of it? I can give you till mid-February. You could go see an attorney. Either you're going to get, I don't have a tip sheet for him. I don't know why not. But
yeah, I'll get an attorney.
just you can go hire an attorney or see the public. Oh, here it is. Let's see. Oh, okay, so I just dismissed, okay, let me put warrant block releases on these cases. Warrant block release, warrant block release, warrant block release. So, okay, they all need warrant block releases. There's a case, you have a case in Shaker Heights and in South Euclid also that you need to.
Those are just fine.
But you have, there's a warrant block on your
Right.
license, so
Okay,
you
I
need
didn't
to
know.
see them about getting that off.
Okay.
Just go to the clerk's office. You don't have to have a hearing. I don't know. I don't think. You
Right.
wouldn't have to have one here. So I've written warrant block releases on all these cases. There is a warrant. You have an outstanding warrant
For who?
from, well, Heights Hillcrest. I don't know what jurisdiction it is.
Oh, that's that Shaker Heights, yeah.
So if you would just have a seat, we have to call them, make sure it's a valid warrant, see if they want to come and get you, which I doubt they want. But I'm going to give you a new court date. Let's give them
February 26th.
2/26. Okay, that's some time to get some of this straightened out, and time to get an attorney, if nothing else, at 9 o'clock. 2/26/19 at 9. Have a seat, sir. Okay, you're charged with wrongful entrustment. This is a misdemeanor of the first degree. There may be an amendment available to you. I don't know. You have the right to an attorney on a misdemeanor of the first degree. Certainly willing to give you a continuance to go get an attorney. There may be an amendment at a lower level offense available to you today. If you want to talk to Ms. Jackson to determine that, you can certainly do that and see if you could get it done today.
Yeah.
All right, at least have the conversation.
Your Honor, the city moves to amend the charge to unsafe motor vehicles, section 437.01, in exchange for the defendant's plea of guilty.
Okay, Ms. Miss Jackson, we have Miss Jackson and Miss Jackson, no relation, I assume. All right, so Miss Jackson, count one is amended to unsafe vehicle. Maximum fine is $150, no jail days, no points on your license. Do you understand that?
Yes.
You understand you have the right to a trial or a trial by jury on the original charge. There will not be a trial. You are entering a guilty plea to an amended minor misdemeanor charge. Do you understand that?
Yes.
Do you wish to enter a guilty plea to count one as amended to unsafe vehicle?
Yes.
I accept the guilty plea. I do make a finding of guilt. Let's see. Who is, I can't really read the name. The writing's so little. Do you know who was driving your car?
Yes.
Who is that to you?
My husband.
Well, you know where to go get that 75 in cost from then, right? Okay. 75 in cost. Thank you. Have a
Thank
seat
you so
outside.
For a videotape copy of this episode, call 664-3571 with the following information on your TV screen.